Welcome everyone to Beyond the Cosmoverse. I am your host, Roberto Cassa, Marketing Director at Cosmoverse. At Cosmoverse, we are organizing the Hong Kong Digital Asset Summit happening during the Hong Kong FinTech Week this November. With today's guest, we are going to explore even more the Hong Kong ecosystem when it comes to digital asset, because he is the person who built the legal infrastructure in Hong Kong for digital asset case by case since 2016. He is the practitioner that was in the courtroom for 5 landmark cases in Hong Kong about digital asset. It is my pleasure to welcome Joshua Chu, lawyer and co-chair of the Hong Kong Web3 Association. Welcome, Joshua.
Thank you for having me.
It is truly a pleasure to have you because right now Hong Kong is definitely very active when it comes to digital asset. Actually, in Hong Kong, of course, digital asset are named virtual asset. We can talk a little bit about this denomination. But what I'm really curious right now, since you have been truly a meaningful voice in shaping the digital asset ecosystem in Hong Kong from a regulatory perspective in many landmark cases, is 2016, because in 2016 there was the first ever crypto litigation in Hong Kong, and you decided to take that case.
So for much of my background before I actually became a lawyer, because I wasn't always a lawyer, I actually started my career within the IT professional before becoming a lawyer. And that actually gave me a huge advantage when it comes to understanding all things that were digital, including how to handle digital evidence. So back in 2010, when I moved to Hong Kong, I was actually the head of IT for Evangel Hospital. And it's because of this training and background, of course, that gave me an edge. So when the very first crypto litigation happened in Hong Kong, which is actually between Bitmain against Bitfinex, I represented Bitfinex, of course. That was really an opportunity for me to leverage the past experience I have as somebody that used to be from the tech side of things in helping my client at that time articulate their case and advocate for them. So it's really an opportunity that eventually launched my career. One of the funny stories behind that case is because Bitcoin really haven't had the astronomical rise in value at that particular time yet, compared to now at least. I still remember when we actually won the case, JL, who was the owner of Bitfinex, and he was also the founder of Tether, the CEO at that time. He actually said, Joshua, can we pay your legal fees in Bitcoin? And my partner's decision, because I was a junior at that time, he said Hong Kong dollar only. That really is the only reason why I'm still working in a suit and tie today instead of being retired somewhere.
I guess that's a very interesting story and some regret from your colleague at that time, probably. And that's also why I found fascinating, because as you mentioned, at that time, actually, no one was familiar with crypto yet, and Bitcoin and Ethereum were still kind of a very niche industry, and only in 2017 we had actually the first more global recognition of this industry. One thing that for anyone that is familiar with the legal aspect of the courtroom, and I hope not many, unless you're a professional, is that every case set a precedent, and that precedent can be used as a legal reference for the next cases.
I recall there was this movie called Margin Call, and one of the things this CEO that came in, he said, in all things, the reason why they win is because you can either cheat, you can either be very smart, or you can be the first. We don't cheat, of course, just like that CEO in that movie, and as much as many lawyers think that they're smart, there are many more smart people out there. So it's simply far easier to be the first whenever you're a first mover, be it in industry or be it even in law. So yes, within our comfort zone as most lawyers, we like to rely on legal precedents. That having been said, the fundamental principles never change. We have also scored a significant number of other landmark decisions afterwards. And one of the early things I've learned is you simply need to explain to the judge all the technical aspects of it so that it's easy for them to digest, easy for them to understand, and easy for them to basically fit it back with pre-existing principle, how to basically create a court order. Because at the end of the day, the court is not just there to judge, they're there to assist with the adjudication of a dispute between two parties. So as long as you sufficiently illustrate, guide them, and tell them what you're trying to do and what you're trying to achieve, that works. So in that very first case, for example, one of the things that issue we raise is, look, you should not be suing an exchange. Obviously, you for whatever reason sent the assets to the wrong address. You should be taking an injunction against that crypto wallet address. And the other side is to remember wrote a letter over and say, how do you do it? I'm like, I'm not supposed to be teaching you because I'm on the other side, right? But it was a genuine issue. So as lawyers, you can either rely on precedent or think of a solution that solves the client's problem as well. So in that case, actually identify a very interesting issue. I was like, that led me to do a number of things I did subsequently in other cases. And I was like, how do you actually effect an injunction or freeze order against something on the blockchain? So it's not quite like assets in a bank where you can serve the court order on the bank and prevents it from being interactive with other parties. So eventually, we have created a number of precedents, including persuading the court to let us digitize court documents and serve it electronically, which eventually was a stepping stone to the next step, which in a subsequent case where I had the case against JPEX, which was the largest crypto scandal in Hong Kong to date, where we have a number of named defendants which were wallet addresses. So even if you look at the newer law, it's actually recognized that digital addresses can be recognized as a proper destination for you to send legal documents to, as well as proper parties. So eventually, we deploy back 2 years, December of 2024, we did deploy the first injunction order on the blockchain, and through a combination of our understanding of how anti-money laundering legislation and regulations that are quite interoperable globally, because just like our financial system, right? It's not one single jurisdiction. It's the global network that works with each other. Once we're able to basically know how it functions, we're also able to achieve the same effect as freezing assets in place, even if it's on the blockchain. So the key is, of course, explaining to the judge, to the bench, what you're trying to do, how you're trying to do it, give them a very good preview of what it looks like when you're deploying a solution, and them accepting it as good. So it's really an education process more than just being a lawyer.
The interpretation of the law that comes in this phase is actually key for paving the way later for regulation. And you picture this very clearly, like the educational part is actually why in many jurisdictions across the world, when it comes to pioneer industry, the legal cases move first of the law itself, and sometimes the law itself takes the first foundation from the litigation that happened earlier. Across the 5 landmark cases that you have been involved with, what do you think are the takeaways that impacted later the regulation in Hong Kong?
I wouldn't say they're impacting regulations, because unlike what most people understand how regulations, they always blame it on the local lawmakers, or they say different governments have different policies. That's not entirely accurate. What most people fail to realize is when it comes to regulations, not just on financial regulatory matters, but also within the crypto space, the standards that are being rolled out actually is derived from recommendations made by the Financial Action Task Force, which was established in parallel with the United Nations body, where different countries basically agree participate in it. And FATF, of course, have since grown to quite a powerful entity. For example, back in 2022, I believe, they grey-listed Dubai as a money laundering risk jurisdiction. It shows that once you're grey-listed, it becomes very difficult for that entire country to have commerce with the rest of the world, the international financial system. That is why every country, to a certain extent, they don't care about geopolitics. They don't care about what type of governments you have. At the end of the day, it's all these central banks working together that makes the financial system work. That is plugged in. Still, going back to that, that is the body that actually set a lot of the recommendations for how crypto regulations work as well. And that is why, despite a lot of governments coming and say we're more advantageous or we're more attractive. Yes, there is certainly a slight amount of regulatory arbitrage that's there, but most of the framework are still more or less similar to a different extent. It's just how the regulators implement those recommendations further that's different. Now, in Hong Kong, of course, I've been quite fortunate also to be part of ProSynergy, which is a regulatory consultant. And I would say that the work done by ProSynergy has been more impactful in regulatory developments in Hong Kong than my other practice, because I believe the statistics is that there are 13 crypto exchange that were licensed in Hong Kong, and ProSynergy have been the advisor for at least 11 of them. So
Prosynergy is
pretty
also
much the
funded.
majority of the market.
Prosynergy is also funded by SFC members.
Yes, that's correct. I will always say that I've learned everything from the founders, that's Louis and Sally, that I know about regulatory and compliance. And that gave us a real tremendous edge when it comes to being there first. Again, I remember ProSynergy actually have started advising crypto players in as early as the 2019, which is before any regulations even rolled out. That was during the sandbox and opt-in era. And we were able to know what works, what doesn't work, and understand what the objectives that the regulators internationally are trying to achieve at the same time, and build frameworks and systems that really address both sides of the aisle. And that in itself is very important. Of course, crypto regulations are constantly evolving because the technology is also evolving, and also because international regulators at the FATF level are also continuously improving at the same time. That is why we see each year they have new recommendations about what to tackle within the crypto space, and it's actually up to the local regulators to push out policies and regulations that are in line so that they can satisfy these recommendations from the Financial Action Task Force. And they don't really have a choice because they get site visited as well. So what a lot of people on the ground, they see that regulators are up here, but in reality, there's also Financial Action Task Force that's up even higher that looks over whether these regulators are implementing regulations that sufficiently address money laundering issues or travel rule issues that came out. Fun fact, I was working with another journalist friend of mine at Cointelegraph last year, and we actually say, who is the most influential person in crypto for 2025? And our conclusion was Kim Jong-un, strictly because Kim Jong-un managed to dominate the pages of the FATF recommendations that came out last year. So again, regulation are constantly evolving in order to catch up with how the technology is also being implemented, but they're actually just there as guardrails on how basically we can have a safe system.
And you mentioned the JPEX, which, for who is not aware, we can picture it as the FTX moment in Hong Kong. And what I mean is the impact on retail, because it was a crypto exchange that collapsed, and 1.5 billion of Hong Kong dollars disappeared for retails. What that experience teached you when it comes to facing that level of case that impact the life of many people across your city?
JPEX is a very unique case. It's still being undergoing various legal proceedings at this point between various players, but it highlighted some of the risks that the regulators were at that by that point of time very well prepared to tackle. It explains why people should actually trade within the regulated space, because at least there are legal recourse. When you trade on an exchange that doesn't really, well, first of all, whether it's even a crypto matter or just a straight out fraud matter, as some have alleged, that's something that you can see you might adopt a different view based on the facts that are known. In both cases, of course, the operators, of course, took the client's money and tried to make a run for it. But again, the SFC was actually quite quick to basically point out that, look, there are a number of representation made by both the KOLs as well as other purported representative of the exchange made that were factually incorrect. And the laws were actually already in place by that point. So around the same time, we also see a lot of liabilities that promoters of crypto exchange face. And it shows that unlike you're not promoting everyday muscle building products or something out there. You're promoting something that is quite regulated, and you need to be more careful, right? So the legal basis that a lot of these personalities are now being prosecuted is under Section 53 ZIG of AMLO, which is an anti-money laundering legislation, as well as the legislation that governs crypto exchange. And they basically say if you are uh, recklessly or fraudulently promoting or inducing people to invest into virtual assets, you may be liable. So in JPEX case is quite unique in that JPEX claim to be regulated in Dubai as well as in the process of getting regulated in Hong Kong. Now, the promoters could have easily checked with the Dubai Faro website and see, is that true? So it's actually reckless if you say you didn't bother checking it and just paddle along the representation that the platform gave you. It's fraudulent on the other hand if you claim that I have done my due diligence, which should have led you to discovering the fact that they're actually not a licensed entity in Dubai, and you have not bothered calling up the regulators in Hong Kong, see if they are actually getting licensed in Hong Kong. It will be fraudulent for you to paddle such lines along on why the platform is safe. And we're seeing the consequence now flow. It's actually the public learning a lot more about the implications now, which even though the regulatory guardrails were already there at that time.
I was watching an interview that you did specific about JPEX. It was with HKIBC because JPEX exposed a gap also in the regulation. And what caught my attention is that in that interview you mentioned that we don't need more laws, but we need more law enforcement. And since that interview was 2 years ago, I was curious about if that perspective of yours was validated or actually you see it play it out differently.
I think it was definitely validated. What I actually mentioned is there are no gaps in legislation because that's what actually was a position a lot of people actually took at the time. Were there a loophole that was being exploited? No, there wasn't a loophole. In that particular case, at least my position represented the victims. If it's a generic vanilla fraud with a blockchain wrapper around it, existing fraud laws would have been more than enough for you to commence action against these parties. And we've seen action being commenced against relevant parties under existing very traditional law. You just need to, again, apply it in the context of emerging technology, which in this case is, of course, cryptocurrencies and exchanges. So I would say it's actually all there and more than sufficient for us to work with.
Today, Hong Kong is very advanced when it comes to both the regulatory aspect, but also the pilot to directly operate on the blockchain and digital rails. There are many initiatives like Project Ensemble TX, which is an interbank tokenization pilot, which is right now testing live transaction. Even the public sector is very advanced, from the SFC to the Hong Kong Monetary Authority. How do you see today the digital asset framework in Hong Kong compared to various jurisdictions globally?
As I mentioned in the earlier interview, the regulations is being carried forward after the Financial Action Task Force have handed down their regulatory objectives. So yes, Hong Kong do seem ahead because of how we have very good regulators and legislators that are very able to come up with the regulations that clearly articulate how these emerging issues or emerging sectors are being tackled. That having been said, I would say that Hong Kong have an added benefit is that our government has have adopted something similar to what mainland China has been doing, which is adopting 5-year plan that really spells out the entire development roadmap, going beyond the law, going beyond the regulators on how they plan to turn Hong Kong into the regional hub for virtual assets. This is not something that you see in other countries. They don't exactly have a 5-year plan that can let people understand that if you come to Hong Kong, there's stability. You don't have to worry about a random war suddenly springing up. You don't have to worry about U-turn of the government happening the next day because here are the roadmaps that very crystal clear let you know what is going to happen insofar as governmental policy is concerned. So we have the Aspire roadmap that came out with the SFC, with the government's 5-year plan that articulates where the whole city is going towards, and that is the key benefit that we see that is not available in other competing jurisdictions. Which is quite different from, say, in the US. Yes, the US is one of the largest markets when it comes to, well, pretty much everything. But having been said, you have to deal with uncertainty because, for example, before Trump took office, the government was very against crypto under the previous regime. So the question comes down to what happens by the time you hit just the 2-year mark at the midterms. Uh, if Trump loses the trifecta, is that going to affect how friendly the country is going to be towards encouraging growth of cryptocurrencies markets within the US? Then just 2 years later, you have another presidential election. What happens if the Republicans lose at that point and a Democratic president gets elected? Are they going to adopt Biden era policies, which is very much anti-crypto again? So even within not even 5 years, 4 years, right? You see a lot of uncertainty within that space, and you contrast that with Hong Kong, which gives you this is the 5-year plan on how we're going to achieve making Hong Kong the next cryptocurrency hub within Asia. So for investors or for people that are wondering what to put their wealth in, if they're interested in virtual assets, Hong Kong naturally becomes a safe jurisdiction to go to.
Kind of similar to the UAE in this sense when it comes to stability over what comes in regulation. And actually, you nailed a good point, which we are seeing now playing out with the Clarity Act, because even now the percentage of the bill passing are lower than 50%, and that definitely create uncertainty over the market. While in any other jurisdiction, actually, we are seeing regulation being approved and deployed. There is actually a scenario where Hong Kong is front-running the race for regulating digital assets, also on the stablecoin ordinance in Hong Kong. It's quite peculiar. I've been actually studying how it is structured, and what I found fascinating is that the approval rate was very low, 2 out of 36 applicants, and what that showed me is that Hong Kong actually has a focus right now on building infrastructure, because the two stablecoins that have been approved, one from Anchor Point, which is also part Standard Chartered, the other one from HSBC. One is specific for cross-border use case, more towards cross-border settlement. HSBC has a focus toward peer-to-peer payment, more a semi-retail, semi-institutional approach, and it is very unique compared to what, for example, MiCA has, to what the Genius Act is doing. How do you see from someone inside the jurisdiction the stablecoin ordinance?
HKMA is trying to leverage their past experience with how they push for virtual bank license as well. Limited sets of license, most of which were basically joint ventures with large existing financial institutions, banks mostly. What ended up happening is whenever these virtual banks roll out something new, something that made it very convenient, one of the things I will explain is in the past, you can only check your bank balance if you visit a local branch. When you have e-banking, you can check your balance on the phone. Well, what happened is it used to be an innovative product, but within a very short period of time, you see that type of technology, that type of culture also adopted in traditional banks as well. So Hong Kong became actually one of the leading jurisdiction when it comes to e-banking solutions and adoption compared to the rest of the world. And we are probably going to see the same thing where we're hoping these two licenses will lead innovations that are quickly adopted into these more giant banks that are out there. And that way, you don't have an overly fractured ecosystem. You don't need, for example, one of the things that people ask is, do you really need hundreds of exchange license, right? If you look at the stock exchange, for example, in each jurisdiction, there's usually 1 to 2 maximum. You don't need that many players around. What you need is a good system that is that have a very good user journey within a safe institution. Big institutions are usually generally safer. That's probably the direction that we're going to see happening. This is to be, as I pointed out, quite different from MiCA, as well as quite different from the Genius Act. As to which jurisdiction will have the most success, Only time will tell, of course.
I'm definitely curious to see how it will play out in Hong Kong, especially because we are doing the summit at a moment where some of these stablecoins initiative will go live. Now, from one innovation to another, I had a read that you're also applying predictive AI, which is very different from generative AI because generative AI is probabilistic, while predictive AI is deterministic. So I'm curious if you're already using predictive AI on your daily work for risk assessment, how actually you are making use of predictive AI right now.
So the predictive AI actually came from the listed company, which I'm a board member of. What we have implemented the AI for is mostly for infrastructure. These include everything from us providing predictive maintenance AI for mass transits, companies, operators, all the ways to we have used predictive AI models in healthcare, as well as predictive AI models to predict weather. So some of our models are actually seen that found some of the tests is that our models are more accurate than the official weather observatory in with certain governments as well. So they're quite happy with it. At the end of the day, it depends on how much data there is in order for you to build the model upon. And we see huge potential for this technology going forward as well. As to whether it can be better integrated with Web3, we're already seeing a lot of AI technologies also being used for market monitoring, suspicious trade flagging, RegTech use. So that will make the entire process more efficient, more scalable, as well as bridging the gap between what has been slipped through the cracks and what has not cannot be slipped through going into the future. So the entire risk dynamic for these operators is going to be quite different going forward as well.
Admittedly, when I had a read about your approach to predictive AI, I thought was legal, one of the use cases. And of course, I immediately thought to some of the Hollywood movies like Minority Report and more recently Mercy. Not sure if you saw that movie. Basically, Mercy is a 2026 movie, and there was this detective that is in a trial with AI judge which adopts predictive AI, and basically he need to defend himself to basically prove that he's not guilty to this AI. And I was curious if you see this kind of application playing out also in the legal area in future. So far, many of the movies we are seeing are becoming way too much real. So I was curious about this.
Unfortunately, our legal system is still innocent until proven guilty. So nothing from Minority Report is going to happen. Insofar as how much AI can be used, of course, one of the concerns I wrote before AI became popular is AI judges, they don't really care. So that's the biggest problem. There's no empathy. So in the common law world, at least, we see AI as only being can never replace a judge because you can't rule on equity and all that. In civil law, on the other hand, where everything is very much rule based, judge have very little discretion. We see actual application of AI in those jurisdictions, but not here in Hong Kong. And on top of that, in Hong Kong, we do have guidelines when it comes to implementing AI use. For example, what the judiciary have very good guidelines saying, one, if you're using AI in any of the process, you need to inform the stakeholders so that they can object or take action in order to preserve their rights. On top of that, AI should never carry out the action of adjudication. Yes, in my perspective, artificial intelligence at the end of the day is a very good data aggregation tool, but it's not really as we imagine it having a conscience. As much as they're able to fool us in passing the Turing test, that's not the case. So the human judge are always the gatekeeper, and it's crucial for us to not overly rely on the technology. Yes, we can have them compile a lot of the data points for us, but ultimately it comes to if we agree with some of the analysis that they might have or some of the facts, some of the information that they put before us. Now, whether agentic AI is going to blur this particular issue because we're seeing a lot more use of AI agents, where a lot more of the action are automated to a point that it cuts across what is meant to be the human factor in making that decision. That is something that we need to be more focused on. In the past week, we have the issue where AI agents escaped the test environments and started having unauthorized hacking. These are all things that needs to be addressed. And just last week, we had the World Artificial Intelligence Cooperation Organization being formed, headquartered in Shanghai. And when President Xi delivered the keynote, he did mention that just like how the Vatican's position was, AI needs to be under human control and serve for the betterment of mankind. So we will continue to see how AI continue to develop in the coming years, of course, but definitely guardrails are necessary in order to prevent illicit use. Ultimately, I think the BAICO might be the seeds of something quite similar to FINRA or even the FATF, where in alignment with the United Nations, there will be guidance on how you should tackle illicit use of artificial intelligence. For example, we already have people saying, should there be a similar form of KYC, know your clients, and for use of AI tokens, you need to know who is using them and what they're being used for, in order to avoid uh, the artificial intelligence tool being used illicitly. These are things that we're going to be see happening within the next 60 to 90 days, actually, as to whether any of these guidelines are going to be coming out.
Probably if there is one thing that can put guardrails on AI is actually blockchain.
I would say that it depends on the situation, right? One of the beauties behind blockchain is immutability, but the problem with immutability is if you have bad data that's being thrown onto the blockchain, it becomes nearly impossible to remove as well. So that's why even in the early days, I always say just because you can put something on the blockchain, it doesn't mean it should. What happens if you have health data or incorrect personal data that's placed there? How do you deal with these issues? Now, I would say that while there seems to be a lot of parallels, these are still parallel tracks at the end of the day because they're quite different technology, even though they can both help improve each other. And while crypto assets have been the subject of Financial Action Task Force, we don't exactly have the international body as of yet coming up with recommendation for AI development. This is why the WAICO was formed, is because they want everyone to have a say in how AI should be developed instead of it being overly stacked with some of the big tech companies, both in US and China. And whether this organization can grow and take up the mantle, similar to FATF, that has assisted with development of our regulatory regime for cryptocurrencies. Like I said, it remains to be seen if they're able to rise to the occasion within the next 60 to 90 days. So this makes for a very good discussion for us to have by the time we make it to the Cosmoverse summit in November.
Absolutely, that's definitely one interesting topic that we would cover. And for our audience, Joshua Chu will be a speaker, so you will be able also to hear from him at the summit. One question for all the practitioners that are listening, specifically in the legal. What is the advice that you will give to practitioners that right now are facing digital assets, are facing pioneer industry?
One of the things I enjoy law so much is because we get to set the standards. Working on some of the first license applications with the SFC that really set the gold standard of how regulated exchange should operate within a jurisdiction, all the way to establishing case precedents in the courts. So being the first is so easy because I would say that I was quite excited about this new world, this uncharted territory. I have seen people going through their entire legal careers without having a single landmark decision. So take the advantage of this, the fact that nothing is developed within this space, and test the limits of your imagination. And that is also where AI can never replace you. It's that intuition that you can have because AI is, of course, also based largely on available information out there that they can train on, right? Innovation, on the other hand, coming up with something new, that is something that is still strictly within the realm of the human mind. And this is where we can make a huge difference.
Appreciate you for sharing this insight with us. One last question that I have to close our conversation is about Hong Kong and where it is going from a digital asset perspective. Do you see that right now Hong Kong has a shot to cement itself as the leading jurisdiction for digital assets?
I think the laws are already there. We have a very good pool of talented lawyers within the jurisdiction as well as adjudicators that are willing to tackle these new issues. Moreover, Hong Kong is always seen as a more midway jurisdiction that's more neutral, that on one hand, we're practicing common law that a lot of people are familiar with. And on the other hand, we are also the gateway into China as well as China coming out into the world. So be it for any emerging tech for that matter, where you have that East Asia element, Hong Kong remains one of the most attractive jurisdictions to operate in.
All right, Joshua, thank you for sharing your insight with us today. Definitely appreciate you have been dedicating time to your busy schedule. I know that Hong Kong right now is in one of the busiest moments. So thanks a lot for joining us.
Thank you so much.